and gentlemen, I can come to you and I can say, don't convict. It's not here. I have that right. I have that luxury. This job gives me that luxury. It doesn't give me a lot of money, but it gives me that luxury. I can get up in the morning and look at myself in the mirror and say, I tell you the truth. I will never ask for a conviction unless I should, unless the law says I must, unless he is proven guilty beyond a reasonable doubt on credible evidence that you can trust, that you can rely on. I can never do it otherwise. That's my obligation. And that's why I'm standing here before you today. Because we have proven it to you, ladies and gentlemen. If I thought for 1 minute there was a conspiracy...
Be seated. Ladies and gentlemen, would you have a signature, please? Is withdrawn from the courtroom. Ms. Clark, the last comment that you made, if I thought for a minute there was a conspiracy...
I would get to finish it. It would be my obligation to dismiss this case.
We're close here, counsel.
Your Honor, in view of the...
This has been highly impressive. I'm sorry.
Sit down.
No, sorry.
You're close, Ms. Clark. I realize it's not a complete thought. But what you can argue is what the evidence shows. You can argue ethical obligations that prosecutors have. I'm just cautioning you that you're close here. You're close to the line. You're not over it yet.
Thank you, Your Honor. I was...
Mr. Scheck.
Excuse me, may I just ask for one point of clarification? The thought as I completed it is acceptable, is it not?
It is.
All right.
But the eyes, every time the eyes get in there...
Yes. The only... Let me just mention this. I have never had a defense attorney make an argument like Mr. Cochran made. Nor have I ever seen a defense attorney get up and ask for jury nullification in this way. But when they do...
It was very artfully phrased.
I'll reserve comment. But what I'm saying, Your Honor, is that when a defense attorney does take the gloves off that way, hit below the belt the way Mr. Cochran does, the law permits us to argue our ethical obligations. The Court's aware of that. Under People v. Bahia, under U.S. v. Wade, we have the right then to argue what our obligations are. I get to tell the jury the truth, that I have a luxury they don't have, a luxury I didn't have until I joined this office. They have to represent guilty people and stand up before the jury and say it hasn't been proven, no matter how well it has been proven. I'm sorry,
counsel, you're objecting to her argument to the court?